Hi everyone, my name is Juliana and today I'm going to walk you through a case I've been working on. The story started as Mrs. Barbara Stempler went to see Dr. Speidell for pain and constipation. She was then diagnosed with fecal infection and was admitted to the hospital where her treatment started. But the next morning she had difficulty breathing and emergency procedures were then performed, but then she still passed away. Mr. Stempler filed a lawsuit against Dr. Speidell and this case went to trial. For preparation, Dr. Speidell's counsel, aka the defendant's lawyer, wanted Mr. Stempler to sign authorizations for discussion of patients' medical records, mainly with her other treating physicians. Mr. Stempler refused to give his consent because he is afraid that this will be inappropriate disclosure of patients' confidential information. Defendant lawyer then filed a motion to force Mr. Stempler to give such authorization as he would like to gather information from the other physicians through interviews. The judge granted the defendant's motion and Mr. Stempler appealed the decision in the current court. The issue here is whether the defendant's attorney has the right to interview the treating physician informally without presence of the plaintiff or the plaintiff's counsel. There are two sides to be considered here. Well, doctor-patient privilege may be damaged because well, there might be a leak of confidential information and patients should be able to see their doctors without fearing that such information will be obtained by other parties, especially to use against them in court in this matter. But on the other hand, there is not a statute and court rule saying that you cannot interview treating physicians for this information, and also informal interview provides an alternative for other than formal depositions because they are much more expensive and normally depositions take a much longer time too. Patient doctor privilege was not recognized as common law in New Jersey, and in a prior case this privilege was rejected. Courts in other places, in other states in the country, all have different opinions on the matter. So the current court decided that it is really important to consider both sides of the parties because both plaintiffs' and defendants' rights should be protected. The defendant's attorney will have to provide reasonable notice of time and place, and also a description of the scope of interviews before the actual interview happen. The physicians will be notified that participation in interviews are totally voluntary, and they can consult the plaintiff's counsel if they have any concerns. The plaintiff was given a choice of a protective order if they see any signs of prejudice coming from those interviews. That is the end of the story, and I hope you enjoyed it, and thank you so much for listening.